In one particular case that I know of, the private investigator went out and was not a government agent, but went out and started tape recording all the conversations with the counterfeiters. Those counterfeiters were in California. Well, there's a law. You have consensual monitoring laws, and it's not permitted in every state. The last thing I want to do as a prosecutor at trial is have to turn over my private investigator's criminal record for violating the law in those states. And so they need to be very, very careful of what state you are actually doing the investigation in. Now, prosecutors worry about a lot of things I mentioned before when we're working with the private sector, with the attorneys, with the investigators, with the trademark holders. We worry about the bar. A prosecutor, like any other lawyer, can lose his or her license to practice law if the ethical codes are violated. We worry about Judge Liu. If there's a feeling that the government is too close to a victim, such that that victim has too much control over whether or not the prosecutor's office takes a case, well, they can have the case disqualified. In fact, this happened in a case, People versus Eubanks. The DA's office was disqualified by the judge. We worry about the jury. In some cases, if the jury perceives that the trademark holder was too in bed with the prosecutor, it can have a devastating effect on the case. The appearance of impropriety is very, very important. It's very important to avoid. Internal ethical investigations by DOJ, we have our own internal ethics. So what I'm trying to get at here is that if your prosecutor seems a little bit nervous to work with you and they're not used to this, give them a little bit of leeway because this is an area they're not used to. I'm going to skip over these. This is in your notes, though. People versus Eubanks and Habarian versus Superior Court. These are two cases that basically deal with the first one, Eubanks, where the case was dismissed because the prosecutor's office, but for the industry's financial resources, would never have been able to prosecute that case. And there's all sorts of reasons why, in addition to that. But it's a case where the DA's office was actually disqualified. I would say that in contrast to that, the Habarian decision was a case where the prosecutor's office was not disqualified. But without getting too much into these cases, I would say that the court looked at the economic impact. How significant is it? And I'll just give a quote. Is the assistance of a nature and magnitude likely to put the prosecutor's discretionary decision-making within the influence or control of an interested party? That was in Eubanks. They're going to ask, does the assistance affect only the police department and not the prosecutor? In a case, U.S. versus Adamson, law enforcement expenses to travel to Houston to execute a search warrant were paid for by the private sector. That was seen as okay. If they had flown the prosecutors there, it would not have been okay. So the subtle distinctions that happen in some of these cases, you have to look at the billing structure. Look to see if there were any independent reasons why the resources were being offered by the private sector. How does this play out? Well, the issue presented is whether resources offered by a private party in connection with a criminal investigation or prosecution may be accepted as traditional assistance, or are they going to be categorized as gifts? So what's traditional assistance? Well, Mark said it before. Traditional assistance, identifying the crime, alerting law enforcement to that crime, turning over the fruits of the internal investigation, supplying anything that could be subpoenaed, such as records, identifying your products, your trademarks, your copyrights at the undercover purchases, at the grand jury, at trial, estimating the internal damages, assisting the government in determining the retail value, and also testifying in the grand jury and at trial. Okay, that's the easy stuff, but here's the hard part. What if it's not traditional assistance? What if it's not in that category? This is going to come up all the time with intellectual property cases. Law enforcement's going to turn to you and say, love to do the case, don't have the resources right now to do it. And you're going to say, well, let me offer you some things. What's the problem? Well, we can't store this stuff. It's going to cost millions of dollars to store this stuff. You hear that a lot in the state systems. Okay, that's a problem. Well, we can't accept you have a cooperator who's working for you. I'm not sure I can use that cooperator because you're paying for him. Well, how does this play out? Let's talk about that cooperator for a moment. Let's say that an industry, an association has a confidential informant. And they say this confidential informant just got into this organized crime group and they're buying all sorts of counterfeit pharmaceuticals. Come over to Ed Tarver and say, hey, Ed, we have a great case for you. And Ed says, okay, what is it? Well, this informant's buying all these counterfeit pharmaceuticals. Well, the question is great. Can we use that informant? You're paying for him. We're not paying for him. He's not our guy.